The National Prosecuting Authority has confirmed that its doctors have assessed the former president's health. Prosecutor Advocate Billy Downer says while the military doctors have found that he is not fit to stand trial, the NPA medical team found otherwise.
Surgeon General's doctors who treat Mr. Zuma rendered reports on the 30th of August 2021 in which the bottom line is that they say that he is not fit to stand trial. The NPA's doctors rendered a report on the 13th of September 2021 to the effect that he is fit to stand trial.
Our senior politics reporter Ziyanda Ngcobo is in court following that story for us, and she joins us live. Ziyanda, as we touch base with you this afternoon, what would you say have been some of the key outcomes? Perhaps let's focus on the latter part of the afternoon first, where we saw Advocate Dali Mpofu putting forward his arguments for the removal of a prosecutor.
Absolutely, and you would have heard Advocate Dali Mpofu delving into the reasons as to why Billy Downer no longer, I should say, deserves a title to prosecute by virtue of his behavior, that he cried when you heard that the charges against former President Jacob Zuma would be dropped, and also talking about the fact that, well, they don't want to get too deep into the factional battles within the National Prosecuting Authority, but and all of them would be disqualified. Leonard McCarthy, Bulelani Ngcuka, but he's saying it's unfortunate that Billy Downer is the only one who is still around. But to talk more about what's come out in court today is Mpumelelo Zikalali. You've been with us throughout the morning. Quite surprising that this special plea has actually been heard, and Dali Mpofu emphasizing that his client did not want to postpone. Is it because of the medical records?
I think so. Let's remember, if you had persisted in terms of the application or for the postponement application, the reasons would have been brought in, probably medical records would have been placed between to the court, and there's no way in which you can protect them once they're in the hands of the court. So at this stage, the only way in which you can make sure that they are within the position of the former president and they are not out there in the public, let me use inverted commas in terms of that, it would mean that you don't even touch them and say, I'm ready to proceed, which is quite different from what was stated earlier. Let's remember we were once here a while ago in which a whole day was set aside in terms of arguing of the importance of the physical appearance of the accused, so that the accused can be able to give instructions, understand the nature of the proceedings, and also follow them as you go along. But today it was quite a different story. But let's also remember there is provisions within the Criminal Procedure Act that allows in terms of the accused not being there. And where you are dealing with matters in which the accused will not have to give out instructions, there is no cross-examination. It is purely legal arguments, as you have heard today. You can make an application in which you say, yes, my client fully understands his rights, and he has entrusted me to ensure that I'll be able to protect them as we move on today. Let's proceed for the sake of time. Let's proceed for the sake of making sure that these matters are brought to finality, which is what the court adopted today in terms of saying, let's hear the arguments and let's get on with them. If we are proceeding with that, then there's no need for us to even interrogate the medical records. I don't want you to even keep them in my possession.
And I wanted to touch on that because at some stage then Judge Pitkun relieved Advocate Moses Kakane and the other witnesses in the form of Arthur Fraser, the outgoing National Commissioner. Does it mean that that matter is now done, or is it possible that they may be called back at a later stage?
I think if the proceedings today will be able to conclude with no postponements, then you could say that the matter has been put to bed, it's done and dusted. However, if on the next occasion we come back and there are still delays, and in which, as you've heard earlier, there's allegations or submissions of viva voce evidence being able to must be led, then they may come back at a later stage to sort of state the health status of the former president. That can also be used at a later stage when the main trial is about to start, because we must also remember We are also dealing with the trial within a trial at this stage. We still have the main trial that must be discussed and will be well ventilated. Maybe they may be called at a later stage, but in terms of the conduct in which they've conducted themselves, you could say that the matter has been put to rest. I do, however, have sort of a reasonable suspicion that, taking into account the applications which are taking place in other courts, Advocate Skakane may have to come back and do a bit of work in terms of making sure that those medical records are not opened up to third parties. The medical privilege of those medical records is kept, let's say, a secret for now, or if that particular privilege is exercised to ensure that everything goes according to plan.
Let's deal with what Advocate Mpofu has been tackling this afternoon with regards to Advocate Billy Downer's prosecutorial title and the reasons that he's outlined. I mean, it's not the first time we've heard this. In fact, some have argued that this is a repetition of the permanent stay of prosecution. What does Advocate Dali Mpofu need to say to ensure that in his arguments the outcome is going to be the acquittal that they're now seeking?
Basically, is saying on the first part, let's widen the approach to the definition of no charge to prosecute. Let's not limit it to administrative procedures alone. Let's go to the conduct of the prosecutor, in which we would then say, by the way in which the prosecutors conducted themselves, they stripped themselves off of the charge to prosecute. They are well invested or too invested in the matter. They are not objective anymore. Their sole intention is not only that justice must be served, they simply want the person who they are prosecuting to be convicted. Now, that's the first part. Now, the second part, dealing with the other issues, is that the aiding of particularly the Democratic Alliance, the way in which they've conducted themselves by leaking alleged information to the media, proves what Advocate Dali Mpofu is saying. But linked to that, he's saying, I don't want you to remove him. I want to treat this trial as a mistrial, to put it in simpler terms. I wanted to be the court to come to a conclusion that by that particular conduct, the right to a fair trial has been so traversed and so contravened to such an extent that even if you get a new prosecutor to come in, that same violation will still exist. If you accept my argument, then please discharge my client or find my client not guilty, so that at the end of the day he is acquitted.
Mpumelelo Zikalala, he's a legal expert with us this afternoon, explaining what's happened in court so far. You would have also heard Judge Piet Koen alluding to the fact that he's not available tomorrow, so it would seem that's why he's trying to get through the proceedings as much as possible today. But also confirmation via Dali Mpofu that in fact the former president is in Gauteng. He's no longer at the Escort Correctional Facility. That was read out during Dali Mpofu's explanation as to why the former president is not present in court today, and that he in fact in writing has granted permission for the special plea to go ahead without him.
Ziyanda Ngcobo, thank you very much for that update.